Hello, hi, welcome back. I'm just making one or two minor adjustments. It's been a little while. I hope everybody's doing okay. We have a lot of there's too much. There's too much stupid. There's too much dumb. There's so much stupid. There's so much dumb. But we're back to today. We're gonna talk about Reiketa Law. And we're doing our Vic Mignogna retrospective. For anybody who doesn't know who Vic Mignogna is, he was a prolific voice actor. He got quote-unquote Me Too'd. Basically, faced a bunch of consequences for some shitty actions he took that he admitted to and posted about, and he's been bemoaning his circumstances ever since. People who supported him through this that ended up being quite the, what's the word I'm looking for, instigators of a sort of hate train surrounding anybody who was a victim of or spoke out against behavior like Vic Mignogna's is Reiketa Law. And for anybody who doesn't know who Reiketa Law is, he's a law tuber. He's on YouTube talking about legal shenanigans, and he sucks at it. Last time we were here, he got actual malice wrong for defamation, which was, you know, kind of basic stuff. So I digress. Let's jump into this, because fuck this guy. Last time we watched this video, we watched the first one hitting his playlist, Weeb Wars Vic Mignogna, from 5 years ago. Now we're gonna go and jump ahead a little bit, and we're gonna pull something from, like, the following year, right? Let's just jump, like, real lawyer explains the safety concerns, like, potential tortious interference. I mean, I've done videos talking about that. Fear the Beard with Reiketa Law and Ty Beard on Vic Mignogna. That one might actually be very interesting, but that's not. Anime convention contracts. Whoa, beard ethics. Ethics? You want to talk about ethics? I don't know. Hello, hi, welcome. Oh, yes, reminder last week of early voting. Hey, if you got voting in your state, make sure you double check and make sure you're registered or have whatever year. I'm not American. Go vote America. You're concerning me. Ruling for Vic Mignogna, featuring Ty Beard. This one might be worthwhile, because this is at least one of the decisions. Then there was, like, Funimation and Case catch-up. Let's start with that one, because this one is 2 hours long, and I don't want to listen to Reiketa Law talk at me for 2 hours. Here we go. That's for the following year. This is what I wanted to talk about. Mignogna lawsuit hearing results. Vic kicks back, scoring a win. Bourbon review. That's, like, his long stream. Special bourbon review. Legal news and booming. Oh, boomerang. Okay. Vic's request and legal news. I get Jesus. Funimation didn't accuse Vic of anything, right? Technically, they didn't. We looked at that. We looked at it on Nick Reiketa's stream. Technically, they didn't accuse him of anything. It's kind of was a one-to-one, and I'll grant you that, but in a legal sense, hearing day, Ty Beard talks, asset strategy, like, fee ruling. These are all 4 years ago. Ty Beard ethics response. I know Reiketa did an interview with Vic specifically, and that's sort of what I'm looking for here. But this just kind of gives you an idea on the amount of content that was being made about this at the time. What? Vic's appealist extensions. An appealing stream. Vic appeals 1. Vic Mignogna state statutes. Monica and Roy missed the deadline, allegedly. Alright, so let's start with this one and see where it goes.
What's up, guys? Welcome to Lawsplaining the Interwebs. I am your host, Nick Reiketa of Reiketa Law, a small law firm in central Minnesota, and this video is an update on the status of the case filed by Vic Mignogna against 4 defendants: Funimation, Monica Rial, Ron Toye, and Jamie Markey. Back in February of 2019,
Based on what we covered last time, sorry, I had to unmute myself. Based on what we covered the first video we did on this, in this little mini series I'm doing, he had said one of the people that Vic Mignogna should be going after was legally, in a legal sense, was Mars Girl. I wonder why she was never listed, because I've never seen her be listed as a defendant in anything, and especially like in any of this stuff. So I'm wondering why she was never brought forward. I'm curious to know. Then again, I'm jumping ahead by, this was October 13th, 2019. So I jumped ahead like a bit.
Vic was effectively removed from the anime industry largely due to the allegations and accusations of these 4 defendants. In April of 2019, Vic Mignogna filed.
I'm sorry, are you stating that as a fact? Because that would be defamation. Sorry, I'm just going to put him back real quick. Yeah, February to October.
Rial, Ron Toye, and Jamie Markey. Back in February of 2019, Vic was effectively removed from the anime industry largely due to the allegations and accusations of these 4 defendants. In April of 2019, Vic Mignogna filed suit, and a major new media coverage event of the lawsuit really began to unfold in front of the anime community's eyes.
Are you calling yourself and that umbrella guy and Yellow Flash the new media? Because that's hilarious, first off. Second off, did you guys notice that Funimation was listed, right, 4 defendants? One of them was Funimation, and said that it was the accusations of these 4 that caused Vic to lose his job, but Funimation is the anime industry? You know what I mean? I just realized these are still here from yesterday. Whoops. Haha, tee-hee. Let's get those out of the way. Don't mind my drinking habits. And my Tim Hortons cup. That stays. That's because that's a prop.
Large part of that occurring here on this very channel. People were able to read filings in real time. They were able to see things that they may have never seen before, such as deposition videos. All of that is still available on this channel, but it's also available in several.
Okay, yeah, he's calling him and his friends the new media.
Other sources as well. And I encourage people who are unfamiliar with the lawsuit to look to those sources, to look to my videos and channel, and to familiarize yourself with the facts from as many different perspectives as you can, so that you can make an objective decision about what's going on here. For those of you that have been following, you know that on September 6th of 2019, a TCPA hearing was conducted in this lawsuit. A TCPA hearing is a pre-trial hearing which allows defendants to suggest that a lawsuit is brought without merit and solely for the purpose of stifling their free speech.
One misnomer here that I don't like is this idea that you need to go get facts from multiple sources. And it's like, no, yes, but also it's a little bit not quite the way. I don't like the way this is being presented here. I think it is important to go and verify a fact. So if you get a fact from Fox News, like they just state this thing, there was an earthquake, then it's like, okay, there was an earthquake is a fact. The earthquake occurred because of the gays is not a fact. So when you're talking about these kinds of things, it's okay. It's good to verify a fact and make sure more than one source is providing a fact, but it's also really important to know what a fact is. And I've noticed that a lot of people don't know what a fact is, and they don't know the difference between a fact or an opinion, or they don't know the difference between opinion and speculation or hyperbole. And like this is a problem. So as much as I can say, like, yeah, if you want to get a fact about a court case, it's probably pretty good to read the court case. Or if you want to know what's in someone's deposition that was filmed and posted, you should watch the deposition. You know, the one where Vic said he tried to sleep with twins. That deposition, for example, off the top of my head. But the interpretation of those facts, like, it's a fact that Vic said that he took these twins back to his room and solicited them for sex. Its opinion about the appropriate and in what way nature of those things, or speculation about like what Vic's approach may or may not have been based on just that information and what he said. There's wiggle room, right? I don't think it's appropriate, but you could have other people that have different opinions. So if you come to a place for X or Y, there's another problem here as well. Nick Reiketa and his friends, including that umbrella guy, were harassing and bullying anyone who had a different opinion than they did. So you were going to have a really hard time. Reiketa is essentially saying, come to me and my friends for the facts, not outside of our conglomerate group that's already working together, that's already friends, that's already like covering the case in the same way. So you end up with like a bias issue, even though you think that you are getting this information from multiple sources. What you should do is get a fact from a primary source and then verify it if it is verifiable, right? I know that sounds like I'm asking you to do a lot of work, but it really just depends on how much work you need to put into it based on how you decide you want to interact. If you're just consuming media, then it's really not that big of a deal if you're wrong personally about Vic Mignogna and whether you have the facts of this particular court case or not. But if you're going to engage in content creation, or if you're going to engage as a viewer or as somebody who wants to go into every single fucking YouTube comment and throw your fucking opinion around like people are going to give a shit about it, it's very, very much in your favor to go to the primary source as best as you can. You'll notice that when we watched the Yellow Flash was not going to primary sources. When we watched the Umbrella Guy, he wasn't going to the primary source. The primary source would have been the deposition. The primary source would have been the article where Vic Mignogna was being quoted. The primary source would be actually reading Vic Mignogna's posts, right? So if I heard right, Nick Reiketa is a con artist who scammed thousands of followers through the GoFundMe. Well, you know, he's not a convicted con artist, so he hasn't been convicted of anything. I think he fucking ripped off the Vic Mignogna fan base for sure. There's never been, and like my associate, a friend of mine, Manya, who comes on with me on Dumbfuck Friday, reached out to Nick Reiketa to ask him for receipts of that GoFundMe that went to Nick Reiketa and to Ty Beard that Vic Mignogna says he's never even seen or touched that money. So if that is the case and there is no receipts for it, there is no like layout, there's no, even Vic Mignogna did not provide any receipts for the lawyers that he got. So not a single one of these people has ever shown a proper receipt for a lawyer and lawyers' fees and how it was used at all. So I think if your opinion of those facts, because those are facts, is that Nick Reiketa scammed the fuck out of Vic Mignogna fans for years, I would agree with you. The fact of the matter is they got thousands of dollars in GoFundMe. No receipts have ever been provided. The lawsuit was a joke and was poorly handled. Those are facts. And it's not it's not my opinion that the lawsuit was a joke and that they failed on multiple fronts. That's what the judge was saying. That's what other lawyers who were following this were saying. That's their opinions. Those are professional opinions. But also it is a fact that they were misfiling and retracting things and not filing the correct stuff. So those are all facts. So if you take those facts and, form an opinion, I don't know if I would call him a con artist, but I definitely call this GoFundMe a scam, for sure. And I think I think they should face consequences. Or they should at least fucking show that they didn't scam people.
It's sometimes referred to as an anti-SLAPP law or an anti-SLAPP motion. Since we're in Texas, it is the Texas Citizens Participation Act. At the hearing, 12 of the 17 counts were dismissed by the Honorable Judge Chupp, who is the district court judge in Tarrant County, Texas, where the lawsuit is filed. Judge Chupp had a subsequent 30 days to go ahead and file the remainder of his opinion on the outstanding charges. In the meanwhile, prior to filing his opinion, he did order all of the parties to mediation, apparently in response to death threats that were sent to the courthouse by a anonymous Twitter person, and also an email or two that was sent to the courthouse as well by a, I'm told, unrelated internet person. I don't know the identities of any of these people other than by their anonymous screen names.
But you have the screen names. So, I'm curious to know. Okay. We're back to this is the problem with these types of videos and streams. This is just him talking. You'll notice that it's just him talking. You'll also notice the tonality change. When he's talking about something that he thinks will be successful for Vic versus something that that's a big fail. 17 counts got dismissed, and he's just like, well, whatever. And he's just moving on like that's nothing. Nick had a bad weekend where he went on a crazy Twitter and live stream rant. Yeah.
That being said, the judge ordered all of the parties to go to mediation prior to him issuing his final ruling. As covered on this channel, there was no result from the mediation. All of the parties walked away from that mediation with no deal worked out, and the judge was left to issue his ruling, which he did the following, I believe, 2 days later. This was on Friday, October 5th. On Friday, October 5th, Judge Chupp issued the ruling dismissing the remaining causes of action against from Vic Mignogna against the 4 defendants.
So the whole thing got dismissed then. So a handful of things got dismissed. Then they went into mediation due to some extenuating circumstances that definitely didn't have anything to do with people riling other people up on the internet for months. And then the rest got dismissed afterward. Okay, noted.
Because this is such a charged event with so many people invested in the outcome of this case for various reasons.
For various reasons. Why? Why are so many people so interested in Vic Mignogna's frivolous defamation suit, Nick? What do you mean? You turned it into a fucking goddamn clown show. What are you talking about? What do you mean? Between the first video we watched in this playlist that has 68 videos on its own, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21, 22, 23, 24, 25, 26, 27, 28, 29. Did I go past it? 30, 31, 32, 33, 34, 35. Like, are you kidding me?
Briefly,
Okay.
Some of those reasons include support or animosity towards Vic Mignogna himself as an individual, support or animosity towards Vic Mignogna because of his status as a voice actor and the characters that people have either liked or disliked, or because of the work that he has performed. Some people may have been disapproving of his vocal talents, and other people may really like his vocal talents. Further, support or unsupport of the individual defendants or the company Funimation itself. And finally, there's another group of people on both.
Okay, bro, no, the people didn't have an issue with Vic Mignogna because they didn't like they didn't like Broly. Like that is such like a mischaracterization. And like, you know, maybe he's gonna go into it a little bit more, but the fact that you led with that for as long as you did tells me that you're trying to minimize, and what he's about to do is he's about to dismiss the people who have an issue with Vic Mignogna's behavior, right? Because that's the biggest issue with Vic Mignogna, is his behavior. It's his predatory behavior, sexual or otherwise.
Both sides of this issue who are more invested in the idea of the hashtag Me Too or cancel culture movement. And you can actually find evidence and articles and media commentary on both sides of this, which really ignores a lot of the facts involved in the case. And more.
I have a question. If you're gonna put Me Too and cancel culture together, do you think someone who is a serial sexual assaulter should have a career that enables them to prey on people? For example, do you think like if a pedophile is in the Catholic Church, do you think they should be in a position of power around children? Do you think a woman who is regularly who is known for assaulting people should have a career, and like, I don't know, let's use date rape as an example. A serial date raper, do you think she should be working at a bar where she has easy access to people whose drinks she can spike and then take home? Because I hope the answer is no. I don't think industry should be enabling predators. So again, whether or not you believe some or more of the stories about Vic Mignogna, or the more egregious ones, even if you take into account only what Vic Mignogna said in his deposition, he should not be at cons. He abuses his position of power to take people out and isolate them and then solicit them, thinking that he's already going to succeed. He literally explained why he targeted those two twins in the deposition. So if you want to talk about the facts of the matter, Nick Reiketa, do you think that somebody in a position of power like that, who has a history of being a creepo and then said out loud that he's a creepo, should be allowed in places where it's easy for him to have access to people to creep on?
More focuses on the idea of Me Too, on the idea of cancel culture, on the idea of misogyny or feminism. There are lots of people coming at this with various perspectives. But when we focus on the actual facts of the case, what we have is a man with a 20-year career. And
if we focus on the facts of the case, it all got dismissed by a judge right before this. So what are you even talking about? All right, a man with a 20-year career. Ooh, very important, yes.
Actual facts of the case. What we have is a man with a 20-year career, and we have a group of people who have come out with allegations that date back 7 to 10 years, sometimes longer. The allegations seem to be unsupported by anything other than...
Incorrect. It's not a group of people. It is individuals with the same story that have been talking about it for a while. Because you have con-goers, you have con staff, and you have voice actors and people in the industry that are not necessarily voice actors. So you don't have a group of people, shut the fuck up, if you want to talk about facts. Nick, you are putting your opinion onto the facts instead of, and your biases onto the facts instead of talking about the actual facts of the matter. What we have is a dude who's been in an industry for 20 years who has admitted to being a fucking creep to convention goers, has admitted to being rude to staff and con staff. 20-year career of inappropriate behavior. Right, exactly. If you want to talk about the facts of the matter, these are the facts. These are things that Vic Mignogna himself has corroborated. Hi, Feline, welcome. If Vic Mignogna's corroborating it with the other people making the accusation, then where else are you gonna go? And besides, these aren't necessarily the facts of the case either. These are, oh my god. Okay, you can't take a post on a forum website that is somebody talking about how they were assaulted by Vic Mignogna and then apply it to the case of the matter, because that's not what the case is about. The case was a defamation case focused on 4 people. You can't blame these 4 people because somebody else made a post over here before these people ever talked about it. That's not a fact anymore. That's you drawing inferences and drawing lines on the fucking knit board. You know what I'm talking? Like the pegboards that have like the yarn. The fact of the matter is you have to base it off of the depositions. And if you look at Vic's deposition and you look at what Vic has publicly said, his statement when all of this was, his initial statement had admissions that he was touching people inappropriately, that he knew he was making people uncomfortable. He admitted to approaching people. He admitted to soliciting fans for sex. He admitted to being rude and problematic towards constaff. Those are all straight up admissions. So if you want to talk about the facts of the matter, Nick, stick to the fucking facts.
And their word, their allegations are undermined by the fact that these allegations remain silent for so long. And not only did the allegations remain silent, but the people making the allegations not only worked closely with Mr. Mignogna, but also were very, very openly friendly and publicly and privately friendly with Mr. Mignogna during the entire time.
How do you know that? You know, even if that's true, right? Like, let's say Monica was friendly with Vic Mignogna, and sometimes you work with somebody that you don't personally like, but you stay friendly with them on a working basis. This is a weird thing. This is like, Vic Mignogna says this a lot too. He's like, oh, well, I was friends with these people and now they suddenly turned on me. Like, I never knew we had any problems. Why didn't they talk to me privately? I don't know. Why didn't I privately pull somebody aside who like grabbed my hair and ripped my head back and was being weird to me and like have a private conversation with them? That's safe. That'll go well. No? Like, what is this weird expectation these people seem to have? It's like, oh, well, why don't you give me the opportunity to gaslight you in private? What the fuck? He's assuming public friendliness would entail a private friendliness. I think he's just basing that off of things that Vic Mignogna has said. But he's just making this statement, which is a matter of subjective opinion of the person. And he's just throwing that out as if it's a fact. And the problem with that is he's got no source. He's not citing anything. Like, is there an interview that you've got? Did you do research? Did you go and find like an interview where Monica and or Jamie and Vic are on a panel together and they're laughing? Tee-hee. If Nick Reiketa called me up to pull me on a stream, I would be friendly. Because that's just being not rude. This is like a weird thing. And I don't know if this is like a man thing, because I see this a lot in men. Or if this is just a thing that happens where men will take friendliness and view it as like some kind of like more than just being generally not a dick if a woman is doing it. And it's like, you guys gotta sort that shit out. God.
It just happened that in February, these allegations manifested into something where the defendants and a few other accusers were manifestly unable to be in the presence of a person they had spent the past decade being in the presence of following the alleged events.
Huh? Manifested? Again, you've switched from talking about the facts of the case versus somebody having a bad experience with Vic Mignogna in a really icky situation, but sucking it up and dealing with him anyway for any length of time, and then finding out he's been doing this to people for a long period of time. That might change somebody's opinion and their approach to dealing with that person, don't you think? It's almost like new information can change your mind about something or someone, and that information will entail your future behavior when it comes to that person or that thing. If I find out tomorrow that I no longer, gravity doesn't apply to me the same way it applies to everybody else, and I can actually drop 20 feet and I'll actually just bounce, then I'm not going to use the door anymore. What are stairs? I'm going to go out my window because it's faster. Like, what the fuck? That makes no sense. Of course. And yeah, at work or at conventions, keeping it professional is absolutely reasonable. It's not everyone else's fault that Vic Mignogna assumed everyone liked him. Because they didn't, like, just be like, hey, Vic, you're an asshole every time they saw him. Like, that might be harassment. What the fuck? Sounds like something my German professor said, that Germans, at least in his generation, have few close friends while everyone else is an acquaintance, while Americans call everyone their friends. Right, friend is up to interpretation. People being friendly, right? Like, these are social languages. They don't have definitive definitions. Right? Is a hot dog a sandwich? Is a taco a hot dog? Like, it's like, culinary is one of the best examples of, like, knowing what something is versus knowing how something is perceived and consumed, right? So if somebody asks me, are you my friend? I'm probably gonna be like, I mean, yeah, sure. Do we talk on a semi-regular basis? Yeah. Do I personally believe that we have a close-knit relationship and are friends? Do you know anything about me that you haven't learned from a stream? Then we're probably not very close friends, right? So we're probably not, like, friends in the way that I would consider, like, I'm going to talk to you about my personal or private life, right? There are different tiers of this friendship, so it's like it's a weird question, you know what I mean? So for Nick Reiketa to just be tossing that around as if that means anything. Vic Mignogna didn't even have to do anything to these 4 people for them to decide they didn't want to deal with him anymore. In fact, I think that's kind of a little bit of what happened, isn't it? People found out he was being this way. People kind of knew he was being this way. People took it seriously for a change because society had been changing with your Weinstein stuff. Like, I still cringe. I was watching Jon Stewart last night, and he was talking to Walsh, and I cringed because Walsh was talking about how great it was to hang out with Bill Clinton, and I'm like, oh, that guy who raped somebody? Cool, great, yeah. So, like, we're not there yet. There's still problems, but that doesn't mean that people should not change because, well, I worked with him long enough, may as well just keep letting him do what he's doing. And that's the problem. People decided to tell him no. And Vic Mignogna didn't like being told no. And Nick Reiketa, being an opportunist, was like, well, let me help you tell people how they're not allowed to say no to you. Hello, everybody vote. Reminder. P.S. Probably don't vote for a rapist.
When pressed by the community for any sort of evidence to back up these allegations, they have not been able to provide much of anything, and this has caused much concern amongst the fans.
Why do you think it's any of your business? a bunch of women corroborating stories, or not consolidating, what's the word I'm looking for here? Commiserating about one dude being a creep. Do you really think what corroborating evidence? What evidence are you talking about? Again, we're back to a lawyer dismissing testimony as if it doesn't count as evidence. It does. It absolutely counts as evidence. Would "you're an asshole" shit be harassment as long... Sorry, let me reread that. Would a "you're an asshole" shirt be harassment as long as it doesn't specifically say Vic? No, I don't think so. It could be considered, like... I don't think so. I think you would have a hard time, like, just wearing a shirt that says "you're an asshole" on it. I mean, you could say that you might be being a prick if like, every time you ran into somebody said, "you wore this shirt." But it's not like... It might not be appropriate, it might be kind of mean, but I think you might need a little bit more than just wearing a nondescript shirt, sorry, I should say, a nondescript shirt. Nick also did the classic grifting scheme during this disaster. Send me super chats to show how you disagree with how Vic is being treated. Yeah, the problem is, it's not... You have to prove... He talked about this in the first video. Vic has to prove actual malice. Everything got tossed out, so there's no reason for any of the defendants to prove anything in court. Also, why would they waste their time with a bunch of people that are sea-lioning them on Twitter? And again, you'll notice that Nick isn't showing anything on screen anymore. He's given up on that. He tried to at the beginning and then tried to pretend that these people said a bunch of shit that they didn't.
Amongst people who are looking in on this from the outside, who are not otherwise anime fans, but are interested in how cancel culture and the Me Too movement works. Whatever your opinion...
Oh, I see. Oh, now you're going from... He says the facts, then jumps into this and calls it lack of evidence. Vic was the one that needed to provide shit, and you failed.
On it, I encourage you to go read the court documents from both parties. They're publicly available in several places. One place you can go and purchase them for yourself to make sure you're getting a completely unadulterated look at them is Research Texas Cases. You throw that into Google, that is a Texas government website which will allow you to look up Victor Mignogna versus Funimation Productions LLC. If you go ahead and do that, you can download any document that's been filed in this case, and you can objectively look at the facts and make up your mind for yourself.
Okay, so which one does he want me to look up again? Did he say he wanted me to look at the... Whoop. No, that one's May. You want me to look at what? The hearing transcripts, the trial timeline, I have it. I have all of it. It's in my Discord if anybody's interested. It's in the thread specific drama under the subheading Vic McDick. So, which part do you want? Which part, Reiketa? You want me to look at? Let's
you
see.
Can go
I
and
want him to re-say it. Which one?
Allegations. They have not been able to provide much of anything, and this has caused much concern amongst the fans, amongst people who are looking in on this from the outside, who are not otherwise anime fans, but are interested in how cancel culture and the Me Too movement works. Whatever your opinion on it, I encourage you to go read the court documents from both parties. They're publicly available in several places.
Oh, just all of them? Oh, you just want all of them? Bro, I've got trial notices. I've got motion briefings in support. I've got a trial of example tweets. I've got the depositions. I've got the attorney correspondence. I've got the TCPA affidavits. I got the Funimation ones. I got all of them. You want me to just read all of them? You're not going to summarize them for me? You're just going to... ah. Fun fact, I found your channel during the beginning of the Vic issue. Really? That's amazing. I love that.
One place you can go and purchase them for yourself to make sure you're getting a completely unadulterated look at them is Research Texas Cases. If you throw that into Google, that is a Texas government website which will allow you to look up Victor Mignogna versus Funimation Productions LLC. If you go ahead and do that, you can download any document that's been filed in this case, and you can objectively look at the facts and make up your mind for yourself.
No, you can't. It got dismissed. Half of your guy didn't even submit shit. This is just a lie. You can't see the evidence that Ron has because Ron wasn't presenting evidence against Vic. He was presenting evidence in defense of the defamation suit. You are baiting and switching your audience. Your audience is going to go to these, see that there's none of this, like, proof that Vic did anything to Monica and say, oh yeah, see, there's no evidence here, so it's bullshit. That's not what the trial was there for. That's not what the hearings were for. This was a defamation case about whether or not these people or these individuals named or this set, the defendants, were defaming Vic Mignogna. Not whether or not Vic Mignogna did things to these people. These were not criminal charges. This wasn't Vic defending himself from allegations, like you've been trying to present it as. This is just a fucking lie. You're not gonna be able to go through that and find the type of evidence that he's suggesting. It's not going to exist in this case. First off, it didn't get that far because it got fucking dismissed on merit, which he just explained at the beginning of this video. Why are you expecting Funimation to put out information or evidence about something that Vic Mignogna did to somebody else when the thing got dismissed on merit regardless? Yeah, maybe if the case had kept going, maybe then you would have to provide a different argument and say that, no, what I believed what I was saying was true at the time. But they never even had to make that argument. Monica and Jamie and Ron and Funimation never had to prove that Vic Mignogna did anything to them specifically. Because Vic Mignogna's defamation case was so piss poor, everything got fucking dismissed off of merit. He had no merit to sue for defamation, to be clear. But even then, even if it didn't, it's not even necessarily going to be the case that they would have had to prove that Vic did this specific thing to them, because there's other stuff that Vic would have, there's other hurdles that Vic would have to jump over. Defamation is not necessarily easy to prove. But this coming from the guy who fucking doesn't know what actual malice is. So, no, Puck's cameo has not yet. Not yet, I don't know where he is right now. Yeah, he's probably laying down somewhere. Somebody in the house is probably eating food. But yeah, there's no... So it's not like Reiketa is sending his fans on a wild goose chase. No, because he's a lawyer. He should know better. He literally just explained how it was dismissed on merit. So he should know that he's sending his fan base to look for information that's not there, setting them up to come to the conclusion that this evidence doesn't exist because it's not in this filing, when it has no place in this filing in the first place, to begin with. So, defamation is one of the most difficult cases to win, especially when you're a public figure. Yeah. Yeah, it can be very, very difficult. Anyway, dumbass, like, did Nick Reiketa or Vic Mignogna's fans notice this? I mean, probably not. Sorry, guys. You're getting played.
highly, highly encourage people to look for those facts. And I do mean to say look for those facts, because they are lacking, is what I'll humbly suggest. There is a dearth of facts coming from some of the parties about where these details took place, who may have seen the events in question. Is there video? Are there photos? Is there anything to support their allegations? You have to be the one to decide that on your own.
No, it's the court's job to decide that, not your job. It's not your job to do that at all. And again, he's setting it up. He's setting it up for failure. He's trying to fucking present this as you ought to go into this lawsuit, if you're reading through it, looking for photos where there's not going to be any. I mean, what else do you want? It's just not what the case is about. Vic has not been charged. You're allowed to form an opinion, but it's not your job. Those are different things. Trying to have it done by the court of public opinion, which simply doesn't work. Well, it especially simply doesn't work after it was dismissed. You've already lost. And now he's trying to spin it around. You don't think they noticed at the time his audience was mostly anime chud fans combined with incel drama communities? Ah, good lord. Didn't they just not renew his contract? Yes, correct. Funimation just didn't renew his contract and recast him in MOOOnday and said that they weren't going to be working with him moving forward. And they said they did an investigation. They also kind of threw in there that they didn't approve of any kind of harassment or assault, but you could view that as, like, linking Vic to that, but it's not a direct accusation. It's more just saying, hey, this shit is going on around this guy, and we don't approve of any of this stuff. Same thing that when we looked at, what was that, Starforge? When we looked at Starforge's statement about Osmongold. Same thing.
Own. For now, Judge Chup, the judge presiding over the case, has dismissed all of the causes of action against Mr. Mignogna. And that has left many people observing this with a lingering question. What's next? What's next? The defendants in this case...
There should be nothing next. There should be, well, Vic lost, oh no. But as we know, this is 5 years ago. And we're in the year of our Lord, in the latter half of year of our Lord 2024. Yippee! I still see this shit on Twitter.
Outside of Funimation have largely made some sort of victory lap, professing their gratitude for the people who have stood with them through this, asking for the anime community to heal, and a bunch of other statements indicating that they believe that this lawsuit is over. And
Nick Reiketa was like, no, I will throw a tantrum, and Vic Mignogna will throw a tantrum, and we will throw a tantrum for a whole nother year until we lose in court again.
Mr. Mignogna, as has been the case throughout pretty much the entire lawsuit, has remained silent on the issue. So everyone's wondering, what's next?
Oh yeah, no, good point, Feline. There was no action. The actions were not taken against Vic. It was Vic taking action against those people. Yeah. I'm gonna assume, I will be charitable here to Nick Reiketa and assume he just misspoke.
The lawsuit over? Do these people get to walk away from this? What happens to them? Are their careers okay? Is Mr. Mignogna's career okay? We don't actually know the answer to most of these questions, but I am bringing you a...
I'm sorry, is Vic Mignogna's career okay? Why do you care? No. Short answer, no. Part of that isn't even necessarily because of this in particular. It's Vic's behavior around it. If Vic had gone to a PR agent and, like, apologized and said he was, like, oh yeah, no, I've been a dick at cons, I'm sorry about that, I'm gonna change my behavior, and he did, this wouldn't fucking matter. Even if he said nothing and then went away, like, took it on the chin and was just like, oh, Funimation ended my thing, I'm just gonna take a step back and assess the situation and like shut the fuck up for a year, and then came back and said, yeah, no, I've reflected on my past behavior and I realized that I was appropriate or not. Or even say nothing. Just come back a year later and be like, hey, I'm applying for stuff again, or hey, I'm gonna be in this, or whatever the fuck. He could have done anything except for the shit that he did. And part of the reason why Vic did what he did and handled it the way that he did was because of people like Reiketa Law fucking encouraging him and enabling him in those directions. And what happens when you enable predators? Bad things happen. Good God. Fuck, dude.
Very specific answer for today. Mr. Mignogna, I'm told, is going to appeal every single dismissed cause of action. So appeals are coming.
Ooh. I like the dramatic pause of him just staring at the camera like a fucking psycho. Woo! Guys, he's gonna appeal. And how did that go again? Not good. It didn't go well. It went real bad.
They should be coming very soon. At the time of the recording of this video, I believe there is something like 10 or 11 days left to file that appeal. So we should see a document soon, and you can follow the filing of that document and any responses on this channel. There is, I do a
follow my channel if you want to see
nightly live stream, and many of those live streams, when there is something to cover involving the Mignogna case.
Hey, what about if you're not biased and you're looking at the facts? What about everybody else's careers? What about the show that Funimation got rid of Vic Mignogna on and replaced somebody? Is that show doing well? Did it do well? What about those things? Why do you only care about Vic? It's almost like your bias is showing.
Many of those live streams are dedicated to that. So do check this channel for updates, but I'm sure you will see plenty of buzz about it on Twitter and in other sources. With that said, I look forward to appeals. I have personal confidence that at least some of the cause of action do stand a good chance to be overturned on appeal by the appeals court. I personally believe that the judges...
Why? You haven't explained why. Why do you think that? You're a lawyer and you're speaking from to an audience with an air of authority who has allegedly read the case and who has an in with one of the lawyers. Why do you believe this? The fact that you're not explaining why is kind of telling.
The judge's final order in the case was lacking in several aspects, and that it left a broad range of appealable points for
such as
the plaintiff to work with. The plaintiff, of course, being Vic Mignogna. So we will see what his team puts together, what they file, when they file. But I wanted to let you know that I have learned that they will be filing an appeal on every single issue. With that said, I bid you farewell. Please like...
Dipshit, it was dismissed on merit. So what are you planning to appeal? That it did have merit and the judge was just, nah? Like, what's your appeal thing? I'm going to go immediately to the next one because he said he's going to put this stuff out, but I'm going to double check the date. So this was October 13th, 2019, and the next one in the playlist is... Give me a date. Give me a date. Give me a piece of that Kit Kat bar. Hey, that's me. No, not until November? Shut the fuck up. Not until November. So he's promising updates that should be coming soon, and it was almost a month later, 3 weeks at least, before this live stream? Alright, what do you got for me?
What's up, guys? Welcome! The volume's on. I checked. Welcome to Law-splaining, the
Oh, I do not like the aspect ratio on that chat. I don't like that.
I am your host, Nick Reiketa of Reiketa Law, a small law firm. Small law firm in central Minnesota. And oh boy, do we have some really surprising and exciting documents to go over tonight. Man, I cannot wait.
Bro sounds really excited. Okay. Justice chat? What the fuck? Oh, this is so toxic. Alright, go.
The legal arguments, the logical deductions. Really, the logical deductions are a thing to behold. They're marvelous, well-founded, thoughtful, and emphasis on the thought. Thoughtful conclusions.
Like thought, T-H-O-T thought? That kind of thought?
Conclusions that are being drawn from facts that are only existent in the minds of deranged lunatics, or are just flat out obviously wrong.
I'm sorry, did you just call all of the Vic Mignogna accusers that Vic Mignogna confirmed he did things to delusional? Yeah, a load of waffle, you're right.
So there's that. As you are probably aware, there were some filings late night last night that posted today. We have Rial and Toya's brief in support of sanctions and attorney's fees. We'll take a brief look at that. What? God, I was eating a Pop-Tart earlier. I think I got crumbs everywhere.
I can literally see like the speckles on his shoulders. That's likely dandruff, to be honest.
We are gonna have their sanctions and attorney's fee requests, along with Markey's lawyer Sam Johnson sanctions and attorney's fee requests, and then we're also gonna have Lemoyne's brilliant reply as to why Chris Latos should be deposed, which I can sum up for you now as in, the other side doesn't want me to, which means I have to do it. That's proof. So we've got solid logic, we've got bad facts, we've got all of this stuff going on.
What is a bad fact? I'm gonna speed him up. That's not the right thing. I'm gonna come on, dude. Let's get moving.
It was it's a mess. It's actually demotivating how dull these documents are. I don't like this part of the lawsuit. Can I be candid with you? We'll be candid. I don't like this part of the lawsuit. I think that's obvious, right? I know many of you are in the same boat. What I don't like about it is because of how Chuck handled the hearing, or rather didn't handle the hearing, there is no way to do anything faster than what.
That's the judge in the case that he mentioned. I know the subtitle said Chuck, but I think it's C-U-B-B, but that's the judge.
What's going on? And what's going on right now is a bunch of stuff that is probably going to get rubber stamped, but won't matter because the appeals court's going to relook at this. And so the appeals court's going to have to go through and redetermine all of this stuff, right? So that's frustrating. There's just nothing to do. And
he's literally complaining that he's annoyed that him and his friends are wasting the court's time.
I hate that this is where we're at, because I really do think that Chuck completely screwed the pooch on how to deal with this TCPA hearing. And upon doing some pretty simple research on the 2nd District Court of Appeals down in Tarrant County, I'm pretty sure Chuck may have never actually fielded a TCPA, because he is not attached to any TCPA appeals. Not any of them that I can find.
If it was it a simple search or was it an in-depth search? Those are different things. The search can be easy but be shallow, as opposed to like you're going in-depth and looking through like a large number of court records, and that takes a lot of time. So what? So what if it was? With very simple research, which was no research. No, he Googled it. He used one search bar and said, this man, this filing? Oh, there's none showing on the website.
There are TCPA appeals which have Chuck mentioned in them in some other thing, right? Like he's mentioned in some other document or cited somewhere, but he's not in the case that decided the TCPA, which is baffling because he logically should have had a TCPA hearing or two during his career. Like it seems like that would happen, but I don't know that it ever has. And if it has, somehow no one has appealed it, which is crazy. Crazy.
He's just explaining why his little theory didn't make any sense, as if that explained it. What the fuck?
But because it's crazy because it's such an easy out for defendants, and because Chup has been a judge for something like a decade, and finally because both sides are highly incentivized to appeal TCPA judgments. They just are. So the fact that he's not attached to any of them is just really, really mind-blowing in a way. But that being said, it's really frustrating because had this gone the other way, right? Had this gone the other way and Vic won at the trial court level, even though it would definitely be appealed, we would have just this massive onslaught of vitriol coming back this way.
What do you mean? What are you talking about? So you're allowed to be upset and demoralized, but other people aren't? What vitriol has been coming your way, dude?
And so it's really weird because and they would be talking about how they're definitely going to appeal and this is unjust and all this stuff. Same things.
Who's they? You're talking about like the anti, like the Kick Vic people, right? This is very you jumped from talking about the judge and how the judge is being unfair to that now you would be facing vitriol. How do you know that? How do you know that you would be facing vitriol? The problem is that your case got dismissed. Vic's case got dismissed on merit. It never went to a hearing. And now you're jumping ahead to speculation that if Vic had not just got a hearing but then proceeded to win his case. Here's the thing. I don't think your assessment is accurate because you're skipping a whole length of time of all of this being publicized. And so the information about what did or did not happen with those 4 people would have had a lot more time to settle and have a lot more information flying around and evidences one way or another. But it didn't come to that. So you're not just speculating in a one-to-one, you're speculating into, well, what if George Washington wasn't the first president of the United States? What would the year 2024 look like? And it's like, you're skipping a whole lot of steps here, bud, to make this accusation.
We're saying here, that's the TCPA divides cases like this. This is how it goes. It's so prejudicial to either side, but specifically towards the plaintiff, right? Because if the plaintiff loses TCPA, their whole thing is thrown out and they've got all these fees that are tacked on, which is really crazy. It's really crazy to determine that a lawsuit is without merit simply because some judge decided there wasn't quite enough evidence to bring a case that were any other set of laws involved in the TCPA would be absolutely going to trial.
So Nick Reiketa doesn't believe in anti-SLAPP and thinks that people should not be protected and their money should not be protected by people who would be willing to abuse the law with frivolous cases. What actually I think Nick Reiketa doesn't agree with, by some judge. Some guy. Some judge. This is insane.
Like that's...
Then Vic should have filed better. If it got dismissed on merit due to anti-SLAPP laws because Vic didn't file well or didn't submit enough shit to demonstrate it, that's on your lawyer guy that you got, your real estate lawyer that you got for him, isn't it?
That's an insane sort of thing to think about. That there is something where you go, okay, well, I need more evidence than what you brought, more than your notice pleading assertions, more than all of that. I need more than that.
Any would have probably helped Vic, to be honest.
Even though in a breach of contract or in all of these other things, you would have plenty to say that on this thing, I need more because. And to put that burden on a plaintiff is really frustrating, we'll say. We'll say it's frustrating.
You're mad because they said I need more because you don't have a case? This is part of the problem. Vic never had a case to begin with, and you built it up for a whole fucking year, and then got your butts kicked in court, and now you're pissy about it.
But yeah, it's the law that we have. Well, Texas has, and it's what we're dealing with in this case. That being said, I don't like this part of the case because I know that none of this actually matters. What will matter is what the appeals court decides. That's what will ultimately matter. Now, the appeals court may agree entirely with Chup, but Chup's decision won't make that matter. That'll still be the appeals court making the final ruling on everything. So, until
Yes, it would. The appeals court, if I'm not mistaken, as not a lawyer, takes into consideration the judge's reasoning. What the fuck? Huh? Why wouldn't the appeals court read the judge's ruling? That doesn't make any fucking sense. Oh yeah, by the way, it didn't get anywhere in the appeals court. I don't even remember. Correct me, Chad, if I'm wrong, if there's anybody in here who knows. But I think the appeals court, like, didn't even look at it. They took it and said, you don't have proper justification, and threw it out. They didn't re-review everything. They said, you have no reason to appeal this. You have no new things to present. You have nothing. And you have no justification for us to even appeal in the first place. So they didn't even fucking look at it. This didn't happen. What Reiketa is describing didn't happen. It's not how it works.
Until that the appeal goes through, this is all just sitting there waiting for the moment when the argument gets to start back up. And that is boring. I don't like it. I'm not a big fan of covering the same documents with the same arguments. And these arguments are remarkably similar, and deficient in many of the same ways. But that being said, we are going to go through
They're deficient, but they succeeded? So what's the... Okay.
3 documents tonight. I think this will probably be a pretty short stream. And just so you know, there is no stream.
That's right. The appeals court said that the defendants should have gotten more money from Vic. That's right. I forgot about that. And then I believe 2 of them appealed it to get more fees, and the other one didn't. I think Jamie did not, but Monica and Ron did, if I'm remembering correctly.
Stream tomorrow because I will be on the Dick Show's bonus episode. We're gonna do a Dick Tracks or whatever, dictation over the Dr. Phil tapes. So I'll be on along with several other people. Should be a fun time. But there will not be a live stream here tomorrow. So I'm here on YouTube tomorrow, sentencing hearing, because agree upon are the several mistakes that he made in marshaling his defense. We can talk about those, talk about backing up. That's a big things as show. Friday, we've got, if you're installs and selling them, what it's of course, Drexel talks about it's a conversation that's been fine. That'll be sometime in the near future. Other than that, we're just going to do this little show tonight. We're going to do this little show tonight. We're going to cover these documents. I hope y'all are excited. I think what I'm going to do is I'm going to start with Lemoyne's
I hope you guys are excited about this shit that I said was boring.
Documents. And I'm going to start with his reply in support of motion to compel deposition documents of Chris Slatosh. Then we'll move to Rial and Toye's whatchamacallit, their motion for attorney's fees and sanctions. In that, I'm not going to go through all of the exhibits. In fact, I'm only going to cover one of the exhibits, but it is the article from the Minnesota Lawyer that is about me. And I'm going to cover it, 1, because the guy cannot effing spell my name to save his life. 2, he says he called me multiple times for comment and yet just decided to never leave a message. And 3, there's some interesting opinions from ethics specialists in Minnesota in that document. And I think that's worthy of discussion. So we're going to go through that.
So these guys tried to call you and you just didn't answer the phone or call them back because they didn't leave a message? Oh. Sure. Weird. Irresponsible, one might say.
Reveal the Pop-Tart? Oh, don't you dare accuse me of eating a s'mores Pop-Tart. Filthy. Absolutely disgusting. Strawberry. This guy must have sprinkles only. It's got the covered. Seen along with you. Like, what is this? My goodness. You're a cookie one. They give you 2 Pop-Tarts in a package. Just put 2 Pop-Tarts down with both parts. Do you break bread?
I am a monster. I will only eat 1 Pop-Tart at a time, so, I disagree with Reiketa here. I am the monster who will only eat 1 Pop-Tart at a time, or half of a bagel at a time, or 1 Eggo, even though they come in 2 packs. Sorry, I'm not sorry. I'm a monster and I don't care. He got gifts. Okay, can you get on with reading the fucking document? Okay, here we go. Jesus.
Entire documents, the purpose of the entire document is to paint Vic Mignogna as me, to paint me as Vic, as interchangeable as one and the same. That means that they are literally admitting to conducting a media campaign to silence Vic Mignogna. That's what they're doing.
God, alright, sorry, now I gotta click back. What? Sorry, I got distracted by all the fucking Pop-Tart. Shit. Go on.
I'm not going to say last names. No docs. And hey, I'm not going to say last names. You know why? There's an admitted mass media campaign of shaming against me and viewers. They just went ahead and admitted to it in the documents. So I will not mention last names on the show.
You should be ashamed of yourself, Nick. Both for your current behavior and your behavior back 5 years ago. You've been a problematic individual causing a lot of harm to people for half of a decade.
Because I know that Lemoyne and his legion of con-sluts are out actually actively attacking me and viewers because they're that cool. So, good job.
Well, I mean, when you call people con-sluts, do you really not expect them to clap back at you?
Lemoyne. Oh, and
coward.
For those of you that have read the document that we're going to read tonight, you'll notice, of course, that it says that they're conducting or that there's a constant barrage of shame from the media intended to silence me. But what does that mean when the entire document, the purpose of the entire document is to paint Vic Mignogna as me, to paint me as Vic, as interchangeable as one and the same? That means that they are literally admitting to conducting a media campaign to silence Vic Mignogna. That's what they're doing. Make no mistake, there is nothing else you need to know. He is supposed to die.
Vic Mignogna still has a stream. He streams on Twitch like on Wednesdays or whatever. He streams, he was putting videos out on Twitter. Nobody's silenced Vic Mignogna. That's never happened.
That's what they're doing. Make no mistake, there is nothing else you need to know. He is supposed to die silently alone. And if he doesn't do it, they will go to NPR, they will go to Anime News Network, they will go everywhere they can to put him deadly silent in the ground. And they've admitted to it in their own filing. That's how embarrassing.
Vic recently got married, by the way, not to the girl he was with, and not to Farah, who he was cheating on the girl he was with a whole nother woman entirely. So, this is a lie.
Embarrassingly disgusting these people are. You can't. How dare he? How dare he speak up? How dare anybody speak up on behalf of him? Don't they know? Don't they know that the weight of 200 women has come against them? Emphasis on the weight of 200 women. I mean, to be fair. So,
saw that
yeah. So anyway, they're just admitting to it now, so that's cool. Okay.
Is he just not gonna show the document at all? We're just supposed to... Is he just gonna... He's not gonna... Okay, he eventually shows the document.
Anyway, so this is from Ben. This is a book that he thought I would like. This is The Yellow Sign and Other Stories, which is the complete weird tales of Robert Chambers.
Okay.
It's Lovecraftian in... from... Let's see. Yeah, they sent it, but I'm that stuff. So I haven't seen either of them. Whoever sent that, thank you so much. I really appreciate it. I don't know who you are because Amazon didn't tell me. That is great. Okay. Should we get into these documents? Let's get into these documents.
I don't want to give him a hard time. This is clearly like his hangout live stream, and he's getting stuff from fans and stuff like that. I just want to get to the fucking point.
So here we have the reply in support of the motion to compel deposition and documents of Chris Slatosh. Obviously, Lemoyne is trying to get this reply in front of the judge before his proposed hearing on the 7th, which has been opposed by the plaintiff. And for all of Lemoyne's whining, that's not going to get him in front of the judge. Like, he's not going to just get in front of the judge because he whines about it, as he tries to in this document.
I like how he says he's not going to say last names out loud and then shows a document that has last names in it, so it's superfluous.
So, but let's take a peek. Is that centered? It's not centered well. A little bit better. Okay, reply in support of motion to compel deposition and documents of Chris Slatosh. Defendants, Rial and Toye, blah, blah, blah. Respectfully show the court as follows. I'm sure that they'll respectfully show this. If Chris Slatosh's deposition is irrelevant, then plaintiff has...
The only person that's been disrespecting the court has been Nick Reiketa so far.
As follows. I'm sure that they'll respectfully show this. If Chris Slatosh's deposition is irrelevant, then plaintiff has no need to show up. Does not need to spend any time or fees worrying about what Mr. Slatosh might say. If you know anything about law at all, you know that this is the stupidest line you could say, right? You know automatically that this is the stupidest line that could be possibly written about this deposition. Well, if they think it's irrelevant, they can just not show up and not spend any time worrying about fees. Because, of course, just because it's irrelevant doesn't mean that you're not going to attempt to use it to cause trouble, that you're not going to bully and harass someone, that it's not a perjury trap, that it's not all sorts of things that you want it to be. It can literally be factually and legally irrelevant to the questions at hand, which it is. Which it is. But they're trying to get something else out of it, which they're going to, again, they're just going to say it. They're going to say it all in this document. Wes Nilechan says, my sweet Limois.
So I'm just going to read this out loud. It says, in totality, it says, if Chris's deposition is irrelevant, then plaintiff, being Vic, has no need to show up and does not need to spend any time or fees worrying about what Chris might say. But the fear of driving this unnecessary motions practice, including seeking sanctions on a new objective, only confirms that the court should hear from Chris. The new objection should be overruled, and if sanctions are in order, it is only against plaintiff's counsel. So, Reiketa is presenting this as, if you know anything about law, it's obvious. It's obvious that this is a terrible, terrible argument. But what is the argument? The argument is that Vic Mignogna's side is saying this person shouldn't be deposed because what they have to say doesn't matter and isn't relevant to the case. And the opposition is then saying, or the defendants in this case are saying, well, if he isn't relevant, then it shouldn't matter if he comes or not, and Vic shouldn't have any questions to ask him or shouldn't involve himself at all. And if they want sanctions, it should be coming from that side. So this isn't a standalone on its own argument that's being made. This is an argument that's being made in response to not wanting this person to show up. So the way it works is defendants have proposed this person be deposed. Vic Mignogna makes an argument to say, no, they shouldn't be deposed. And then this is a response to this, not the initial proposition. So if you wanted to say that this is a dumb argument overall, he needed to bring up what the initial argument was, because this is sounding like this is a dumb argument because what it's responding to was dumb to begin with. But it also sounds like Nick Reiketa is flipping it.
MOOOn may not be able to inflate a balloon, but he can inflate his billable hours. Oh, yeah. Well, yeah. We'll see about that. But the fear driving this unnecessary motion practice, including seeking sanctions on a new objection, only confirms that the court should hear from Mr. Slatosh. They should have to do it because they're opposed to it, so then it should happen. That's the legal reasoning. That's the logic behind this whole thing. They don't want it, so that proves the court should hear it. Which, if you apply that in reverse, you could say, that means that the TCPA's discovery stay necessitates the discovery should be shown, should be engaged in. Because if they don't want to do the discovery, then that is just proof that the court needs to see it. The motion to dismiss, if you say it's a frivolous lawsuit, if they're so afraid of fighting this lawsuit, well, it means the court should, it's proof that the court must see the entire case.
Kind of. It's an argument you could try. Like, it's an argument you could attempt to make. That's why this is the second half. That's the conclusion, not the argument. It's therefore because this, then this. Right? So, Nick Reiketa is kind of sensationalizing it, but None of this is weird. It's pretty normal.
Because they're afraid of fighting it. Do we see how the logic breaks down when you...
Oh, by the way, that doesn't work when it's applying to an anti-slap, because the whole point of anti-slap is to say that I shouldn't even have to fucking fight this because it has no merit in the first place. So
just take an A to A, B to B comparison of any other event in law. Well, the opposing side opposes it, so then it must be necessary to do. Oh my God, we've just solved every lawsuit. Every plaintiff automatically wins. Every plaintiff automatically wins because since the defendants oppose what the plaintiff is doing, well then what the plaintiff is doing must be correct.
That's not what the argument says. The argument is saying that it's contradictory. If it's irrelevant and it doesn't matter, then they shouldn't care. But obviously they care, so we should look at it.
Automatically, we've solved the court legal system. Thank God. Thank God. We can now move on to bigger and tougher issues. Let's figure out how to abort Texas lawyers. So that's their solid legal reasoning. The new objection should be overruled and if sanctioned...
Isn't Ty Beard a Texas lawyer? What? It's flawed logic to begin with. Yeah, again, we've got a contextual problem here. The contextual problem being that this is a response to an objection, right? Defendants wouldn't oppose. They wouldn't necessarily... If the defendants wouldn't oppose, they wouldn't necessarily be defendants. Right, exactly. That's the point. Nick's lost in the sauce. It's not applicable because they're different things, and it's not even what this argument says.
Sanctions are in order. It is only against plaintiff's counsel. Why? Plaintiff counsel didn't ask for any of that.
I would like to point out, I am not a lawyer. Just to be clear here.
Argument and authority's new objection is without merit. Without merit. See plaintiff's response to defendant's motion to compel deposition document.
Guys, I said it in a goofy voice, therefore it's blah 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 blah. You already got your shit dismissed because you had no merits.
First amendment, blah blah blah. Okay. Plaintiff abandons his subpoena distance objection to advances the new and legally incorrect argument that the TCPA suspension of discovery survives the October 4th order. I actually said this. I'm not convinced that that's the best argument, that the TCPA stay exists. I know why they're making the argument. They're making Lemoyne either admit that the TCPA is done and therefore it's appealable, or that the TCPA is not done, in which there's still a discovery stay. That's what they're trying to do. I'm not a big fan of that argument. I think I made that pretty clear yesterday. I don't think that's the greatest legal analysis or reasoning, but that's, it's an argument for sure. And it's a trap.
Apparently there was another video or stream that happened the day before this one that's not in the playlist.
Yeah. Side-by-side comparison of the order and TCPA answers whether discovery suspension is in effect. It actually doesn't, though. Order is therefore...
I'm going to read out what the side-by-side actually says. Order at Part 5. Therefore, the court grants the TCPA motion. Plaintiff Victor Mignogna's claims against defendants Funimation, Marchi, Real, and Toei are thus dismissed with prejudice. So he wasn't just normal dismissed, he was extra dismissed. Extra dismissed essentially just means you're not allowed to bring it back. TCPA 27.003, except Section C, except as provided by Section 27.006b, on the filing of a motion under this section, all discovery in the legal action is suspended until the court has ruled on the motion to dismiss, emphasis added. So yeah, it literally does say that. It literally says that the motion was granted and it was dismissed, and the CPA says it is suspended until the court has ruled on the motion to dismiss, which means it was suspended and then it's gone because it was dismissed. Bro can't read. Why didn't you read that part out loud, Reiketa? Baffling, truly.
Or the court grants TCPA motions, plaintiff Victor Mignogna's claims against defendants Funimation, Marchi, Real, and Toei, thus dismissed with prejudice, and then TCPA 27.003.
Sorry, I take it back. Never mind. I'm sorry, Nick. You read it out loud.
Except as provided in 27.006b, on the filing of a motion under this section, all discovery and legal action is suspended until the court has ruled on the motion to dismiss. But if the court has ruled on the motion to dismiss in its entirety, which is the argument that they've put forth to the appeals court that the court has not ruled in its entirety on the TCPA motion. There's still some outstanding thing. One or the other is what they're trying to force. Again, not a good argument.
No, well, okay. Here's the thing. They can dismiss with prejudice, and the ruling on the TCPA is completed, but still want to rule on the fees, which is, I believe, what they're arguing about here. It's just that Nick's not been very clear exactly about what the fuck he's talking about.
Argument, in my opinion, but it's what they're trying to do. And Lemoyne is flailing against it because it doesn't make sense, because the TCPA doesn't make sense. Now, I think the better argument is that they're outside of any discovery period. And maybe I kind of wish they would have argued in the alternative that even if the TCPA say was no longer in effect, that they're outside of any sort of discovery period and thus need to request permission of the court to add additional discovery costs and time to the court's docket, which is otherwise unnecessary. Which would,
yeah, correct. It's a non-argument.
Would allow them to petition the court to do these things and then have this argument over whether or not they should be conducting additional discovery or just filing their documents as Chup told them to do. But, you know, it doesn't matter. We're now past that date, and now they're arguing over this thing. So the court has ruled on the motion to dismiss. Therefore, the suspension is over, and the moving defendants were not required to seek relief under 27.006b. Here, let's see what the footnote says. If his plaintiff now concedes there's not a final judgment, he should promptly dismiss his interlocutory appeal. See, Lemoyne is recognizing the issue here as well. It's an issue for both of them, and one that only the court can figure out. But here's the thing. There's a rule that says that the early filing of the appeal is fine, that it'll just perfect when it perfects. As far as the interlocutory nature of it, it's only interlocutory insofar as the court determines that the final ruling on the sanctions and attorney's fees prevent the rest of the case, the appeal from going forward, or aren't resolved prior to the appeal being heard. So we'll see, of course. The cure for a trial court's violation of discovery suspension is a mandamus to the Fort Worth court.
This is a personal opinion, but I think it's silly to file an appeal before you have a judgment. So before you have a verdict, or before you have, like, a ruling, I think filing an appeal is a little bit silly.
Court of Appeals. This would put plaintiff in a double bind of arguing to one panel the appeal is ripe while arguing to a different panel that no final dismissal has been ruled upon, in addition to spending thousands of dollars to avoid an allegedly irrelevant deposition. But if it's irrelevant, then it's your thousands of dollars. Okay.
No, not but no you. That's what he just said. He said but no you. If they're arguing that if this person's deposition is irrelevant, then why would you spend thousands of dollars in additional filing to prevent this irrelevant thing from happening if it doesn't matter? It's still Vic's money. What are you talking about? Or I guess it's Vic's fans' money that, you know, so who cares? So when he said, no, it's actually your money, he didn't mean, like, Funimation or Real. He meant you as in his followers. It's your money that they're superfluously just throwing away.
And then number 3, nor does plaintiff's interpretation make sense considering if the court had granted the motions only in part, there's no basis to stay discovery until the court ruled on the fees as to the dismissed claims, absent a timely filed interlocutory appeal as to denial of a TCPA motion to dismiss. Maybe. Maybe not. We don't know. We don't have case law to actually support this. If you notice, there's a lack of citations here. And this is the thing that...
There's a lack of citations, he says. Well, like, showing half of the screen being citations is kind of funny. So, I'm sure... I'm going to take Reiketa at his word here and say that maybe there isn't a citation at that spot. But these are citations. So, that's a little bit silly. That might be a little bit nitpicky on my part, but that's a little silly. Tom says, it could go either way. In some criminal trials, you would want to file an appeal to exclude certain evidence if it was gathered illegally. Oh, yeah. If you want to appeal specific things, not like the ruling, which is what Vic was. I should have been more specific. And yeah, there are definitely times and places. Courts are also taking into consideration of its own time, the opposing lawyer's time, the opposing party's time, the opposing party's money, and the time, the money of the deposed. Yes, all of that. You don't just get to willy-nilly decide to depose someone. You need to have standing for it with justification. Correct. Hi, Jessica.
That is going to be lost on this. Now, while I say I don't like the argument, there isn't authority either way on this. And if there were, Lemoyne would have put it in his argument. Presumably, so would Ryan Sellers have put it in his argument. But there isn't actual authority on this. It's a weird period. that isn't guided by a lot of appellate court or Supreme Court guidance. There just isn't much to do with this. TCPA is a mess. It creates an entirely new special procedure with a whole new set of rules outside of every other thing that the court deals with. And so if there's not guidance on it, then it's an argument. This new objection has no merit.
So yeah, he doesn't like the anti-SLAPP law. Okay.
It's a desperate attempt to prevent the cross-examination of Mr. Slaytosh. I don't think it's a desperate attempt. I think it's just a pretty straightforward attempt. As argued below, if leave of court is required, the following sections lay the factual predicate for such leave, which is requested in the alternative. Having invoked Texas Civil Practice and Remedies Code 10.001 and on, the court should award moving defendants their reasonable attorney's fees as a prevailing party under section 10.002c. Court may award to a party prevailing on a motion under this section the reasonable expenses and attorney's fees incurred in presenting or opposing the motion. There's no reason to invoke sanctions other than a transparent attempt to regain the high ground that is irretrievably now lost. Number 5 says, by the time an oral hearing and briefing is completed, plaintiff will spend the same amount of time that Mr. Slaytosh's deposition would last. Well, then that's why you do it then, right? That's why you just automatically let them do it. Plaintiff can avoid costs by not attending an irrelevant deposition, which it's always wise to do that. This is sound legal advice from Wheezy here, is that if your opponent is doing something, make sure you don't engage it at all. Don't do that. If they were to do this, right, what Lemoyne is advocating here would be malpractice. The opposing side is conducting a deposition of one of our key witnesses, but we're not going to go. Malpractice. That's it. That's all you need to know about that. That would be malpractice.
He's so biased and so badly wants this case to matter and for him to be correct on it for some reason that he is willing to say that this lawyer is trying to like promote or advocate or push for lawyers to not behave appropriately with their clients. When what the lawyer is arguing is that you literally called this thing irrelevant, so therefore you shouldn't be stopping us from doing it, and you shouldn't be wasting the court's time and everyone's money filing against it if it literally doesn't matter. They're saying that your fucking argument is bad and you should feel bad. And so the fact that you're presenting it this way is very amusing, actually. I think this is very funny.
And anybody whose attorney says we're just not going to go to the deposition of our key witness by our opposition is committing malpractice. Also,
I'm sorry, is this person irrelevant or are they a key witness? Because according to the document you're reading, Vic Mignogna and the guy you got for him, Ty Beard, argued that he was irrelevant. So he's a key witness or is he irrelevant?
So that, you know what this means is that Lemoyne's lying to the court straight out of it, constantly. And this lawyer is constantly lying to the court when he's making an argument about something your side said. I don't think that's how that works. How is he lying? In what way? Cheating pattern. Lemoyne lying to the court over and over. Or being too stupid to understand that he's just wrong, which we'll get to as well. Unfortunately, that's plaguing Sam Johnson.
I'm sure this internet lawyer that works in a small little area outside of the state that he is discussing in definitely knows better, right? Definitely knows better. In a deposition case. The fact that I can figure this out and read a fucking argument and understand that it is an argument, and so it's going to have some hyperbole in it, or some hypotheticals, or some, well, if this then that it's not legal advice, is baffling to me. Why did people fucking believe this guy?
Johnson also. Plaintiff concede he does not have to attend the deposition. And if Mr. Slaytosh's testimony is irrelevant, there's no reason for him to attend. This resolves his drive-up costs, and plaintiff can make relevancy objections to Mr. Slaytosh's testimony at the evidentiary hearing. Now, here's the interesting thing. Of course, he's not just talking about their own costs, because they're going to impute the cost of this deposition onto the plaintiff. That's obvious. They're not just driving up costs for the plaintiff. They're driving up costs for themselves to put onto the plaintiff.
He's the one who brought it forward. He's the plaintiff in this matter. The argument that you just went over, Nick, was this guy saying, if this person is irrelevant, why are you wasting your own money trying to fight him being in court? That's you wasting the money, not them. That's silly. Yeah, obligatory, don't take legal advice from internet lawyers. Don't do it. Hire a lawyer if you need legal advice. Read the footnote. By the time the oral hearing, that one? Is that the footnote you're talking about? By the time an oral hearing and a briefing is completed, plaintiff will spend the same amount of time that Chris's deposition would last. That's very funny.
Another disingenuous moment by Lemoyne. The cost issue is also undermined by plaintiff's desire to have oral argument on this issue, which only further drives up the costs. While moving defendants are confident in their written argument and would prefer a telephonic hearing to avoid unnecessary travel time, counsel will make themselves available at this court's direction. The court should also notice the plaintiff has not proffered any evidence that any type of attorney-client or attorney work product privilege exists that would prevent Mr. Slaytosh's testimony, including any basis for confidentiality. They don't have to at this point. They can just oppose it on other grounds. They can oppose it on other grounds.
That's what the argument is, dipshit. What do you mean? This filing that he is reading is in response to the guy you're supposed to be supporting in this, and they're filing against this guy being there. So they did oppose it on other grounds. This is now making an argument saying they didn't do these things, and here's why these things matter, and also here's why their reasoning for opposing it is bad. This is exactly what you would expect a lawyer to do. This isn't weird, this isn't dishonest, this isn't bad lawyering, this isn't bad facts. This is just reasonable argumentation. And apparently, for whatever reason, the lawyer, Nick Reiketa, doesn't fucking recognize what those means. And yeah, they don't need to depose on other grounds. Like that's not how any of this works.
They don't have to tell you. The undersigned...
They're literally arguing that your argument for your justification to not allow this deposition is bad, which is literally his job. Like, what do you mean?
Conflicts on Thursday a.m., 9 to 9:11 a.m., hashtag never forget, prior hearing, and Friday 9 to 12 p.m., pre-scheduled family issue, but will otherwise make himself available. Plaintiff has no standing to assert harms to Mr. Slaytosh. Plaintiff concedes that he has no standing to invoke hypothetical harms, such as costs, on behalf of Mr. Slaytosh. If Mr. Slaytosh so chooses, he can contest the subpoena, but Mr. Slaytosh's alleged inconvenience is not a basis to avoid the deposition. But Slaytosh doesn't need to contest the subpoena yet. He doesn't have to. And to demand that Slaytosh, look at what they're trying to do over and over and over again. Look at what they're trying to do. They are trying to punish Chris Slaytosh because he made them look bad. They're trying to punish everyone who made them look bad. Why they've run to the media. It's why they're trying to get me in major media. I have no idea why you would want to put me in major media pieces, but they're trying desperately to do so. It's why Jamie Markey has acquired funding for being a victim by the Times Up Legal Defense Fund. Jamie Markey.
You do realize the irony of him being like, Jamie is sad and crying about being a victim, when literally all Vic Mignogna's been doing, and you have been doing for 5 years, is trying to paint this man as a victim and cry about it, right? This footnote is just informing the court that the plaintiff didn't do that. Yes, correct. This is all normal, expected filings. They didn't provide this reason. They didn't provide this reason. Here's our argument against this reason. So if they didn't provide these things, these are not reasons. So there's no reason for the court not to grant the deposition. Right, exactly. Why does the defense want this guy here if they made him look bad? In what way are they punishing him? What are you talking about? Again, we've got this problem where he's just making these sweeping generalized statements without any justification, which seems to be the exact same problem that the filings that Vic Mignogna made or submitted to the court via his lawyer. The same fucking problem. These sweeping generalized statements and conclusions that are like, you're providing a conclusion without providing your justification. What do you mean?
Her hair was touched. Time's Up Legal Defense Fund, defending rape victims and liars, named Jamie Markey, every day, apparently. But this is why they're doing it. They have to punish.
I wonder if anyone wanted to go for harassment against Nick Reiketa and like get a TRO against him or something.
Punish, punish, punish. Hey, Huber, I know you're trying to avoid the punishment. I know you're trying desperately to do it. We'll see. I wish you the best, man. You seem like a good guy. I wish you the best.
How are you being punished by being asked to to show up to court to give a testimony and at your convenience and at as little cost to you as possible for a deposition. Are you really? This is kind of. Have you ever seen, like, heard the phrase, "Dost the lady protest too much"?
But I think they're probably got knives out for you as soon as it's your turn. Don't forget. They have knives out. Slaytosh made them look bad. He put up an affidavit saying exactly what they did. The whole world can read it from his mouth. From Chris Slaytosh's mouth. You can read that
Well, technically, it would be from his keyboard or his pen. So if he made them look bad in this affidavit, what is the problem with the deposition? He should be able to come under oath and then say the same thing. What's the fucking problem, then? I don't get it. What's the issue? Why, if you wanted to... Because now you're telling me that Vic Mignogna's the one who brought this guy up in the first place. And now he's irrelevant? And now you don't want him to be deposed? And now you don't want him there? And you're coming up with excuses that are getting shut down one after the other by a lawyer that actually knows what they're doing? Go figure. Can't imagine that. And now you're framing that even though you brought this guy up and now we want to, like, depose him, oh, they're actually just trying to attack him? What do you mean? For real? Did you notice, by the way, that Reiketa brought up a perjury trap? If this guy's bad for the defendant, then you would want him to be at that deposition. Right, exactly. Isn't that not kind of weird? How did people buy what Nick Reiketa was selling? Like, why? This is not reasonable. This is not good law. This isn't good. He brought this stream up talking about bad facts and good argumentation and logic and reasoning and argumentation. Like, bitch, where? What are you talking about? If the guy is good for the defendant, you absolutely want him there. Right. So, why are you fighting having this guy at a deposition after you already submitted an affidavit? This is baffling. It's almost like what Nick Reiketa is saying is the opposite of what the actual facts of the matter are or would be. Go figure. Bad facts? You're praising this guy for being so good against the defendants. And then you're like, but we don't want him there. Well, why? That doesn't make any sense. Oh my god.
Monica Rial and Ron Toye, this is a fact, called Chris Slaytosh and pressured him to remove Vic from Kamea-Con. No matter how smart Judge Chupp could be in flat out ignoring the fact that an owner of a convention under oath stated that Monica Rial and Ron Toye engaged in a conspiracy and conspired with other attendees to sabotage the Kamea-Con show because Vic Mignogna went, because Chris Slaytosh honored a contract that he had made before he contracted with Monica. By the way, Monica begged to go to Kamea-Con after Vic was signed. After Vic was signed, Monica asked to go to Kamea-Con.
How do you know that? How do you know any of these things? Yeah, conspiracy. Facts not in evidence, Nick. Yeah. There's so much wrong with what Nick just said. That's a lot of shit to unpack. So, if... Now, I suspect I know which con this is, but I'm gonna throw out a hypothetical. If Vic Mignogna gets signed to go onto a place, and then information comes out against Vic Mignogna, and Monica Rial, between point A and point B, wanted to be a part of this convention, whether or not she knew Vic Mignogna was going to be there, and then decided, you know what, I don't feel safe, I don't want to go there, I'm being harassed because of all of this shit going on, and says, if Vic's going, I don't want to be there because then the Vic fans are going to be there and yada 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 yada. She's within her right to do so. She's within her right to do that. That doesn't make it a conspiracy. Multiple people coming forward and saying that they're uncomfortable with Vic also doesn't inherently make it a conspiracy. By the way. A conspiracy in legal terms, especially, specifically, is something very particular. It's not just, again, part of the problem when you get with streams like what the type of stream Nick Reiketa is doing here is that it conflates terms. It's conflating technical legal terminology with just social usage, right? So if I say evolution, if I say theory, but if I'm talking about Pokemon and I have a theory about the story, or and we're talking about Pokemon evolution, I am not using the same terminology as I would be in biology. Context matters. And part of the problem is Nick Reiketa is not specific about his context. The owner of the convention place could decide as a result that to reassess the decision to allow Vic to come and instead bar him. Yeah, absolutely. That is a reasonable decision. It is not. This is part of the attempt to paint tortious interference, and they were not able to prove that. They weren't able to prove that at the time. They're not able to prove it now. They're never going to be able to prove it because their interpretation of what they presented to Vic Mignogna's fans, and I'm including Vic in that because Vic Blade Up made the accusation of tortious interference. He's wrong. Their presentation is incorrect for what tortious interference actually is. Nick Reiketa's presentation of what actual malice was is incorrect. The description of conspiracy here is incorrect. I'm not a lawyer. And admittedly, I'm looking at this in retrospect. This video is from 5 years ago. And maybe Nick has learned better. But the problem is that the problem stands. This video is a problem. And these guys flooded the internet with this shit and these accusations that they can't prove. They didn't demonstrate any of this. Some guy said something in an affidavit. Doesn't make it a fact, dude. And then if it's all of this is true, and this guy is your key witness that isn't relevant at the same time for some unfounded reason, why do you not want him there? How did anybody ever believe this fucker about any of this? I don't understand. People went to bat for this. People were harassing other people over this. People are still harassing people over this. How in the flying fuck did you listen to this man and believe what he said? He's clearly wrong. As a non-professional, I can understand this. As an outsider, I can understand this. I don't need my future knowledge that I have currently in retrospect, hindsight being 2020. I can see that it doesn't make any sense to have your key witness that has all this evidence that shows conspiracy and tortious interference and then be fighting to not have them show up for a deposition. That makes no sense. It makes me think that your affidavit might be suspicious. And maybe that's why Nick, on his own, brought up perjury. At the very simplest, dumbed-down meaning of tortious interference, they are correct. However, it would not hold in court of law as they mispresent the action of wrongful interference. Watch my video about tortious interference. I know Feline's already watched it. Go watch that one. I have one it's titled Tortious Interference. Go watch that and we can have that discussion there. Because there is nuance. There is nuance to the law. and we can talk about, like, at the barest moment, oh, it interfered with his contract. But interfered with the contract is not good enough in a court of law. You need, not good enough to prove tortious interference. You need more than that. You need to actually show X, Y, and Z. And here's the thing. Somebody saying, hey, I'm supposed to go to this, I'm contracted to play a show at this bar. And I found out that this other person, like, in retrospect, I don't want to be at this bar if this other person is there. And the person who's like, you know what, I've changed my mind. Let's just say, like, they knew ahead of time, they agreed to it, they signed the contracts, and even the guy they don't like already signed his contract. And they called up this place and said, you know what, I changed my mind. I don't want to be there if that guy's there. So, you know, I'm still willing to play the show, but not if he's there. So maybe whatever discussion they have, whether that be a potential rescheduling, whether that be a cancellation of that contract under whatever terms, and depending on the contract, usually both people, there's a way to terminate the contract if you have an agent that's worth their salt. So then that's amongst them and has nothing to do with this other person in any actuality. But if he goes the other way and says, actually, I would rather have you here than that guy, I've heard some shit about that guy, fuck him anyway, then as long as the contract is canceled under the terms of the contract, there is no issue. It sucks for that guy, maybe, but it's written into the contract. Yeah, misrepresent the wrongful interference part. That too.
There's no way to deny the owner of Kamehacon was put into a position where he was required to enforce a legally binding contract. And because of him wanting to enforce his legal obligation, Monica Rial and Ron Toye threatened to cause damage to his show and then did it. They did it.
Prove it, then. This shit was already dismissed on merit. So prove it, then, Nick. You can't. Because you don't. And it didn't happen. At least not the way you're presenting it as.
Nothing can dispute that. No matter how much they want to pretend it didn't happen, the entire world can see that Monica Rial and Ronald Toye are liars. They lied about doing this. When it was pointed out, when the text messages were brought up, their tune started to change a little bit, but they still maintained it never happened. And then Slaytosh comes out and puts in his affidavit that not only was it the text message, but it was a phone call with both Monica and Ron. They lied.
They're allowed to not want to go to a con. It's not a threat to be like, I'm not going to show up if that guy's there. That's my decision to make. And then that person then gets to choose. This is what's happening. And I don't like it, and it happens a lot. You are confusing what it means to have a personal boundary. And it does not surprise me that somebody like Nick Reiketa, who is supporting Vic Mignogna, doesn't understand the difference between a personal boundary and oppression or being pushy on somebody else. A personal boundary is about yourself. You're not breaking any rules by saying, I don't want to go to a place because somebody else makes me uncomfortable. That's within your right. That is you saying, I don't want to be there. If you have something else where it says, I don't want him there, he shouldn't be allowed to be there, that's a little bit different. That's a discussion, though. Now it turns into something else. Maybe. But if they're saying, I don't want him there because I'm going to be there, again, discussion. Not necessarily breaking of a boundary. You know what is breaking of a boundary? I don't want to be touched. I want to hug everybody. I should be allowed to hug everybody. That's breaking a boundary. Because the boundary is about you enforcing yourself on others as opposed to them putting the boundary in for themselves. Right? Even if Monica told the event holder that they would not attend because of Vic, and then publicly stated that they are not attending the event because of Vic, then that is not tortious interference. Correct. If they announced that they were going to an event and then said, actually, I'm not going anymore, and it's even if they said it's because I don't want to be around that guy, they're still within their rights to hold that opinion. They're still within their rights to say that. You argued about free speech at the beginning of this, or sorry, in the last episode. the last video we watched, whatever. Sorry, they're allowed to say that. Technically, lying isn't always against the law either. Also, sorry. Nick Reiketa's been lying in this video. We've already pointed it out in the prior video as well. He lied. You can disagree with their opinion. You could think that's inappropriate, and you could state that you think that that's appropriate, but they're not breaking the rules. There's no law that's being broken in doing so. You can lie without breaking the law. It might be inappropriate. You might be able to show people as being liars, which, again, you haven't shown, by the way. You've just stated these things as fact. You're just making these accusations all willy-nilly all over your fucking channel, which is currently, let's see, 430,000 people. And 33.4 thousand people watched this video stream. To make it tortious interference, you would probably have to have Funny and other companies force cons to ban Vic if they wanted their voice actors to attend, which never happened. That would be closer. The problem is there's another caveat to it when it comes to tortious interference, and it's that it has to be a violation of the contract. And a lot of contracts have clauses written into them that allows one party or the other to terminate under certain circumstances. What Nick Reiketa is really arguing is that none of these cons should have even been allowed to cancel, like having Vic as a guest at all, regardless of whatever was going on. Which is just, well, if you want that, then that's on Vic's manager. Right? That would be on him. Or them. I don't know who they are. I don't even know if he has one right now. Or whoever they were at the time. That's on them to get that contract written in that way. But why would anybody agree to that kind of a contract? Like, it's just not realistic. He's running around calling other people delusional and is just, like, spouting off shit like this. Their real problem is that Vic should be allowed to do whatever he wants, to whomever he wants, whenever he wants, and nobody should be allowed to do anything about it. Or say anything about it, let alone do anything. These people gave their opinions. And they're talking about it like it was some kind of fucking, they did this to Vic. Crying about how much of a victim Vic Mignogna is because people don't want to work with him because he's a dick. Has Vic ever showed the contract to begin with? Not on stream on his own. I do have, if you want to take a breeze through, I'll link the Discord. Copy. There you go. I'll link the Discord here. So if anybody wants to look at the legal documentation, if you go into the Discord there and you go down to specific drama, it's under the content heading. You should be able to find a thread in there that says Vic McDick. And if you click on that and scroll down a little bit, if it lumps you at the top, if you just go to the bottom and then scroll up, it might be a little bit easier to find, but there's all of the documentation is there. So whether or not he actually showed the contract or not, it should be presented there. Let's see, hearing transcripts, mediation order, CP, that's the timeline, trial timeline. That's Toei, that's Ron, that's trial timeline, that's fees and sanctions, that's the appeal prep, Jamie and Ron, that's Funimation, Real, Marshy, plaintiffs first amended motions, proposed orders, strike chart, proposed orders, sanction fees, notice of intent, Beard first amended, notice of hearing, Notice to serve a subpoena. Notice of hearings. Motions to response. Briefs. Joint response. Subpoenas. The thing that he's looking at right now is actually in is titled Trial Motion 3, if you want to search for it. Supportive motions, Ron, Funimation, defendant, motion to file late, strike or disregard, amended strike or disregard, depositions. So yeah, Vic Mignogna's depositions are in there if you want them. Yeah, I haven't been able to find it either. I've never actually seen any of Vic's contracts. I've never seen them. Do they exist somewhere? I don't know. As much as I've followed this case and as much as I've looked around, I've never actually found any of Vic's actual contracts. I've never seen his contract with Funimation. I've never seen his contract with any of the cons. None. Not one. So, like, there's a lot of accusations being thrown out by Nick Reiketa here. Like, a lot. And there's not anything to back it up. He's just drawing legal conclusions without evidence being presented, and as not the judge. And the judge dismissed the cases. So, I don't know what he's basing this off of. At all. It's not like there's a video in here titled Vic Mignogna's actual contract and how X person committed tortious interference. Because why would you do that when you have literally nothing to go on? Literally fucking nothing. There's nothing here. This is garbage. This is him just trying to justify this dumb as fuck argument that why are you not wanting your irrelevant key witness that is so strong and came out and kicked Marshy and Jamie's and Funimation's and Ron's asses to be deposed? Why would you not want that? It makes no sense.
I lied. Over and over and over. They accused me of lying, and I was telling the truth. And you know who
You are lying. You're 100% lying. Because you're making generalized statements and accusations and stating them as if they are facts for information that you have no access to.
It up, Chris Slatosh. Why?
Did you hear the phone call, Nick? You want to yell at these people, right? You want to yell at all the Vic Mignogna people who have come out about Vic Mignogna and stories they've told and demand evidence and photographs and videos, right? Did you hear the phone call that allegedly happened? Or are you just taking this guy's word for it? Where's the phone call? Oh, he didn't record it? Oh, well, then I guess then it counts as for nothing, then, doesn't it? If we're going to apply the same logic. Huh? No? Yeah, nothing about the contract with the convention center. I haven't seen any of those contracts. If somebody, please, if they threw that out there, yeah. If those have been out there and somebody, like, knows of a public place that those were, anything like that was ever posted, please let me know. I'd love to go find it, but I've never seen it. By the way, I don't think that Vic Mignogna should necessarily make that information public, by the way. So don't go digging into non-public places.
Why do you think they want to go after him? Why do you think they want to punish him and cost him money? Because they lied and got called out on.
That is not what this document says. This document is making an argument as to why he should sit for a deposition that he would be able to do over the phone. Dumbass. It is literally an argument about how it's, like, part of this process. And the fact that... Does every fucking lawyer sound like Nick Reiketa when they don't want fucking somebody to show up to court to be like, oh, they're trying to punish this guy, blah, 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 blah. No, Absolutely not. Do you not want to make your case that you brought forward? Does Vic not want to make his case with his key irrelevant witness? This makes no sense. You should be paying him to show up then, if it's such a big fucking deal. Vic should be paying for it then if he needs this guy for his case and he's so fucking important.
On it. Okay. Plaintiff fails to understand the evidentiary hearing is about the amount of the sanction. Unless plaintiff is willing to stipulate to the sanction and the amount and waive his appeal rights, moving defendants must lay an evidentiary predicate for the amount of sanctions they seek. Actually, I don't know that they have to do that. You've decided that you're going to do that, and that's fine.
You have to, as in, if you want to succeed, this is part of the necessary process, and it's an argument. Oh my god, he's so ridiculous.
The sanctions are as the court sees appropriate. There's no evidentiary requirement for sanctions written into the TCPA. There's actually not even a listing for an evidentiary hearing on sanctions in the TCPA.
There is literally a citation right there on the screen.
The motion to compel citations to Landry's Inc. versus Animal Legal Defense Fund explains the necessity of an evidentiary hearing, except you'll admit that that's not from Tarrant County and that there's no authority on this from Tarrant County in just a little bit, including providing evidence.
It's called a precedent. You talked about it earlier. There's been a precedent set as to why these things are necessary. Here's the citation. We think it's applicable here, and we should follow those rules. It's an argument, Nick. If you think it's a bad argument, then say why.
Evidence for the court to examine on multiple factors such as whether the lawsuit was frivolous and or brought for vindictive purposes. They don't have to address this. This is your argument, but this isn't necessarily the way it goes. It's how it was dealt with in one case, and there's little other guidance, and it's from a different district. Unsurprisingly, the response does not mention land.
Is it from a different district, but still in Texas? Yeah, oh, still in Texas. It's not even like they're pulling a citation out from another state. They're pulling it from the same state. That means there is. Bro, do you guys think that Nick Reiketa actually researched Texas law to find out if there were any other cases that used this, and they only cited the one? I'm curious, because usually you don't see more than one or two citation examples of something from what I've read of legal documentation. I'm not a lawyer, but that's what I've read when I've been seeing these things. You'll see like one or two of stuff like that, and I've read some cases from around different places. Some from Romania, some from America, a lot from America. But point being that you don't have to provide more than one necessarily in your documentation, right? If the court's like, oh, I want more than that, and the judge is like, oh, I want more, then you can say, oh, okay, well, here's some other citations. But, God, Nick's argument, his rebuttal is so bad.
Landry or any case law instead engages in wishful thinking that Mr. Slatosh will testify in plaintiff's favor under cross-examination. If Mr. Slatosh will only testify in favor of plaintiff, then he is safe in not attending the deposition, which further eliminates his cost objection. Obviously untrue. This is just disingenuous legal writing.
Why? Explain. Tell Elmo. Unbelievable. How? What is the point of this stream if you're not actually going to address anything?
There's ample evidence in the record to justify Mr. Slatosh's deposition. Plaintiff errs in the assertion that moving defendants, that's errs, I know, it was a joke. The moving defendants did not lay a factual predicate for cross-examining Mr. Slatosh. Mr. Slatosh and Mr. Toye offered opposing testimony which sets up the basis for the deposition. Only if the deposition is relevant. This is, look at what they're trying to do here. He's trying to, sorry, I realize that you can't see when I type in. Opposing testimony which...
Guys, I realize you can't see when I point at the screen. That's funny. That's funny. Come on. Often when it is a rarer argument that has at least two precedents, then you will see two. Yeah. If it's a more common argument, then just one suffices. Yeah. If it is either unprecedented or exceedingly rare, then there may be only one. However, it will also be stated within the argument. Right. It would be like, in this exception, and we believe that this exception applies because. That is usually what you'll see. Victim McDictum? Okay. Very funny. Very funny. That's what I'm gonna call this playlist. When I put these together in a playlist, it's gonna be called Victim McDictum. Thank you very much. Thank you for coming. Thank you, thank you, thank you. Oh my fucking god.
It sets up the basis for the deposition. Again, disingenuous legal writing. This isn't about the motivations for bringing the lawsuit. This is, in summary, Rial and Toya individually and jointly told me Vic was a sexual predator who would be criminally charged before Kamea Khan urged me to breach the contract with Vic. This is a material fact related to the TCPA. Good job chopping that one up, Chup. And then Toya, did you urge him to terminate Vic Mignogna's appearance at Kamea Khan? No. Yes, a self-serving statement by a defendant. That's solid conflicting testimony. Remember how—
In summary, Rial and Toy individually and jointly told me that Vic was a sexual predator who would be criminally charged before Kamea Khan and urged me to breach the contract with Vic. This was, I'm assuming, and then Mr. Toei had responded, did you urge him to terminate Vic Mignogna's appearance at Kamea Khan? No. Right? So, yes, conflicting testimony. You've got an affidavit written by someone who's asserting that these things, the defendants did these things, and the defendants are saying, no, we didn't do these things. Right? Okay, fair. Makes sense. 8 says, plaintiff's errs in the assertion that moving defendants did not lay a factual predicate for cross-examining Chris. Chris and Toei offered opposing testimony, which sets up the basis for the deposition. Why does Nick disagree? He just said out loud that it is opposing testimony, and so this is a reason why we should depose Chris. And Nick agrees that it's opposing testimony. And now defendant has clearly shown cause for there to be a deposition. So, what do you mean? What do you, huh?
It's a self-serving statement by a defendant. That's solid conflicting testimony. Remember how just disagreeing with testimony does not set up any basis for discovery or anything else. Remember that. That was chanted over and over by the other side, that disagreeing with the testimony, disagreeing with something is not a basis for a legal conclusion that there's a dispute. That's been said over and
disagreeing is not conflicting testimony, because disagreeing is about your opinion. Testimony is about you're supposed to be stating facts of the matter. Unbelievable. Unbelievable.
and over. But either way, this is not at issue in the sanctions hearing. Not at all. This breach is in relation to the TI. And good job reminding Chuck that Slaytosh
TI is tortious interference.
Said all this. Good job. I mean, just put it in the record for the appeals court, too. It's good. Further, and absent from Mr. Slaytosh's affidavit is a causal statement as to why his company, Silverfire, breached the contract with plaintiff. The closest he comes to state, Silverfire did breach his contract with Vic by canceling his appearance. And, but what he does not say is why Silverfire breached the contract. Except, I mean, the entire affidavit states why he did it. Because he got...
Does it? You can state a bunch of things and then still have a whole other reason for breaching the contract. And when you breach a contract, you generally have that shit in writing. Was a contract even breached? Is a reasonable question. Didn't Nick say at the beginning of this that Kamea Khan didn't break their agreement with Vic Mignogna? So there wouldn't have been a breach of contract anyway, right? No? In my honest opinion, if I were to play devil's advocate, I would agree to a limited deposition, having it specifically limited to resolving this conflict. Yeah. That would be a good direction to take it in. The thing is that here's one of the problems with Nick's coverage of this, and Nick's coverage overall, is that he is so wrapped into the drama of one side that he can't even recognize a decent argument when it's made. He has to throw shade on everything. He's not reasonable. A reasonable thing for Nick to state here is that that is one of a good argument, but it alone is not enough. Right? That would be what a reasonable person covering this without a bias and like monetary, what's the word I'm looking for here? Conflict of interest, I guess, to put it nicely.
Pressure from the losers. And if Silverfire breached this contract,
you are the losers, by the way.
Because of Miss Rial and Mr. Toye, it was a grievous oversight by the drafter not to include such a critically important statement. It's not an oversight. Everyone reading that affidavit knows what happened.
But is it stated? It's supposed to be. Oh my god, that's massive. That's massively problematic. That's huge. If you have an affidavit from somebody making all these accusations and then they never have. Is that better? And then they never have the actual reason put in? Yeah, I know, right? Ouch. That actually hurt my arm. Oh boy. If you like, how do your lawyers let that through? It's supposed to be under oath. It's supposed to be under penalty of perjury. If you left that out, that alone is also suspicious. That feeling when a goblin knows more about than a literal lawyer about law. In another country! I'm not even American! My brother in Christ, Nick, can you not at least admit that it's just like, yeah, that wasn't directly stated? No, he can't even say that. He can't even acknowledge that. He says it, but he doesn't say, yeah, they're right. He says, no, everybody just knows. Like, no, you're not allowed to draw conclusions like that. That's not how the law works. You need to be specific in your statements. Unbelievable. Unbelievable! This is like trying to establish that somebody did a thing and then the motivation of their thing is just left out of their confession. Like, and they talked about, like, let's say you had, like, a murder, right? Schmurdered. Somebody got schmurdered. And, the person who saw some stuff go on, right? They're like, oh, well, think of, oh my god, I'm gonna use Legally Blonde. I'm gonna use Legally Blonde as the example. In the movie, Legally Blonde, the conclusion of the movie, spoilers, is that one of the people testifying, one of the witnesses, is stating that she saw somebody holding something bloody over somebody else's body. Right? This is like taking that testimony, but saying they never saw the person with the gun, for example. To be like, well, I saw the person, I saw the gun, I saw blood everywhere, therefore they did it. And it's like, but did you see them shoot them? Yes, no. Yeah, the hair bit. Did you see them shoot them? Yes, no. If you're saying, oh, these people contacted me to break a contract, did you break the contract? Yes, no. If you did, why? If you leave out that why and whether or not you did or did not, the other stuff that you're saying is just you can't expect the judge to make the inference. The judge is not allowed to make that inference. They have to work based off of what you told them. If you never tell them why you broke the contract, then they can't take it into consideration. Got a perm but was showering. Right, exactly.
But the more likely scenario is the first draft of the affidavit sent to Mr. Slatosh contained causation language which Mr. Slatosh rejected. Baseless. Absolutely baseless assertion here.
Sorry, let's see. And if they breached the contract because of these reasons, it was grievous oversight by the drafter to not include such a critically important statement. Correct. But The more likely scenario is the first draft of the affidavits. Yeah, it's part of an argument. They're speculating. It's not an assertion. They're saying the more likely scenario.
Any such communications, including rejected drafts sent by plaintiff and his agents to Mr. Slaytosh, put plaintiff on notice of the frivolousness of plaintiff's tortious interference claims. This is baseless. There is zero basis for these assertions. None.
How do you know that? Any such communications, including rejected drafts sent by plaintiff and his agents to Chris, put plaintiff on notice of the frivolousness of plaintiff's tortious interference claim. Any such communications. And that argument is, again, another reason for the deposition. Yet Nick Reiketa has long since lost the plot. That these are arguments to have Chris questioned. This is talking about one of the things they want to use the deposition to find out about. This was either a grievous oversight or it was rejected. If it was rejected, why? Were you sent multiple drafts of an affidavit? Yes, no. These are questions they would have to ask Chris. That's why they want to do the deposition. Nick, you're supposed to be a lawyer. Unbelievable. Unbelievable.
Literally making it all up. Literally making that up entirely. Out of whole cloth. No citations, no evidence, nothing. Let's see. Andrew Morgan.
What do you mean? This is an argument. This isn't where you present your evidence. Okay, no, we're done. We're done. I have to stop. 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 My head's gonna explode. This is what I mean. I'm gonna play this back real quick. I'm just gonna play this back real quick. I want you to listen very carefully to what Nick Reiketa just said. I'm gonna slow him down to regular speed. Listen.
Of the frivolousness of plaintiff's tortious interference claims. This is baseless. There is zero basis for these assertions. None. He's literally making it all up. Literally making that up entirely. Out of whole cloth. No citations, no evidence, nothing.
No citations, no evidence, nothing. This document, let me show you real quick, because we saw it in Nick's video here. I'm going to scroll back. We're going to look at the top of this document, and we're going to look at the type of document this is. Remember, he said there's no evidence and no citations. All right? Reply in support of motion to compel deposition and documents of Chris. This is not a place that is supposed to have evidence presented. This is a reply in support of motion. Ungabung. I'm not a lawyer, I just play one on YouTube. If Nick is a lawyer, then he should know that this is not the place where you put the evidence. That wasn't an evidentiary statement. It was an argument as to why they want to talk to him and why he needs to be deposed. Okay, I have a question. This was like a big deal, right? Like a lot of, like LawTube was talking about this. Like this came up. Why did no other legal YouTuber talk about this? And how bad and misrepresentative and dishonest Nick Reiketa's representation of this document is? Is it this just this document that he was bad at, or was it all of them? Why am I the only one talking about this? Like, I understand that, like, I was talking about it at the time, but I wasn't covering Nick Reiketa's coverage. I was talking about it and following it. I was just following it from just looking at what Vic was saying, as opposed to all these other people. So I was still talking about, but what? Shouldn't people who know about this be on the lookout for this type of shit. And also, again, I'm back to people gave them money. I feel bad for every client Nick has. Do we know if Nick Reiketa has ever had any clients? Do we know that? Do we know the type of lawyer he actually is? Do you know what he's actually, his small firm has ever actually participated in? Like, what the fuck? I do know there was something called a thread knot, where a bunch of lawyers were just shredding this case on Twitter. Absolutely fucking shredding it. So props to those people. Goddamn. That thread was crazy. I'll see if I can find it and link it into the description. There was somebody I was following on Twitter that did actually a really good job talking that was covering this. Let's see if I can find them real quick. Give me a second. Let me see. Here it is. Catherine Tucson. I'm gonna send you their Twitter link so you can take a look at their stuff, because they're actually very well put together. If he had clients, when was his last one? If he had a client, I would show them this shit and be like, are you sure you want this guy as your lawyer? Would that count as fucking tortious interference? I don't think so. Nope. I don't think so. There's also some like really weird connections of a video that I watched about Nick Reiketa. There's a lot about Nick Reiketa. There's a lot of information about Nick Reiketa out there, and all of it leads to him being a sussy little baka. So, Jesus Christ. Oh, yeah. Yes, Alex, I agree. I hate that shit. I recommend the Brave browser. Better to be mistaken for a lawyer than a retail employee. It's like, yeah, I've worked in retail. It's just not this retail right now. I'm not even dressed the part. Oh, no! You were, like, walking around in the store and people were asking you shit. Alright, I'm gonna stop there. This is indicative. I think this is indicative enough of the way Nick Reiketa was handling things after the appeals. So next Monday we'll look at Tug and see what video he was making in and around this time and see how he was handling it, as well as Yellow Flash. Actually, I believe I'll do Yellow Flash first, then I'll do Tug last. So next week we'll go back and look at Yellow Flash in and around this time. Yeah, it's a browser called Brave. If you just Google search it, it'll come up. Feel free to check it out. But I don't know. The amount from when we covered him like a couple weeks ago, last month almost, Nick Reiketa has become more brazen in misrepresenting the law and misrepresenting legal documentation. There would not be in the document that he's looking at what he is telling his audience they should find in there. He's lying. He's been lying. Whoever was calling him out for lying was correct. I'm gonna get out of here. Thank you for joining me. I'm gonna go get some food. Puck is here. Hey, buddy. Come here. You wanna come say hi? Hi. Hello. You wanna come say hi? Me. Hi, buddy. Yes, you're a good boy. You wanna come say hi? Let me see. Hi, buddy. Boop. He's a good boy. Yes. We got a very end of Puck. I just don't know why anybody would listen to Nick Reiketa. I think that's my conclusion. Why would anybody listen to Nick Reiketa? Why do we care? He's clearly misrepresenting the law. He's been misrepresenting the law for 5 years plus. And now he's in a shitload of trouble with the law. Surprise, surprise. Do you guys think, final thought, do you guys think Nick Reiketa will be disbarred? Given what's been going on with him, do you think that he would be disbarred? Feel free to leave your reasoning in comments down below. I'm getting out of here. Thank you so much for joining me. I'll be back next week. We're gonna talk about this a little bit more. I don't understand how anybody could fucking listen to this man. Like, he makes no fucking sense. Nothing he says makes any fucking sense whatsoever. Like, it's clearly just a fucking LARP. Like, what the fuck, dude?